found yourself staring at some really dense legal text?
Oh, yeah.
Maybe like a contract or a government notice, and just wished you had, I don't know, a secret decoder ring?
Definitely. It can feel like trying to read an ancient scroll sometimes.
Exactly. That feeling, that sort of confusion when faced with complex, sometimes really old-sounding language, that's exactly what we're diving into today.
It really can feel like a maze, almost designed to keep people out. But our mission here, for you listening, is to give you a bit of a shortcut.
A shortcut. I like that.
Yeah, the core principles that judges, lawyers, maybe even just curious citizens use to unpack all this dense text. We're aiming to turn complex sources into, well, clearer insights.
And we're focusing specifically on how laws, particularly acts of parliament, are actually read, understood, and then, applied.
Precisely. And our sources for this deep dive, they're kind of like a masterclass in legal methods, offering a really structured way into this field, particularly looking at the Ugandan legal context.
Sounds fascinating. A journey into clarity. Let's start right at the beginning then.
Sure.
So, just to kick us off, what exactly is an act of parliament? And I guess, why do these laws, which you'd think should be clear, often need so much interpretation anyway?
Right. Well, at its most basic, an act is simply a law that's formally made by Parliament.
Okay.
Here in Uganda, the Constitution gives Parliament the clear mandate to make legislation, Articles 79 and 91 specifically. And pretty much all our statutes are formally called acts.
Okay, so acts are the basic building blocks of law. But if they're laws, shouldn't they be, perfectly clear? What exactly is statutory interpretation, and why is it so crucial?
That's where it gets really interesting. Statutory interpretation is the process courts use to figure out the precise meaning of these acts.
Okay.
And then apply that meaning to real-world cases. You see, sometimes words in an act have a plain, obvious meaning. Easy enough.
Right.
But very often, there's ambiguity or vagueness. Maybe a word could mean two things, or a phrase isn't totally clear in a specific situation. Judges then have the job of sorting out those uncertainties. And they use, well, a whole toolkit of methods to find what you might call the true meaning intended by Parliament.
And it's not just judges doing this, is it? This feels like a core skill for anyone working with the law.
Absolutely.
Yeah.
Judges, obviously, when they're deciding cases or, say, directing assessors in criminal trials. But lawyers, advising clients, they have to know what the law means for your specific situation.
Makes sense.
And law students, studying, scholars writing about the law, anyone seriously engaging with the legal system needs to be able to do this. It's fundamental.
Okay, that makes perfect sense. But if we dig a bit deeper, why is interpretation so necessary? It feels like it goes beyond just, a tricky word here and there.
You're right, it does. There are a few big reasons. First, separation powers. Parliament makes the law, but the courts have the judicial authority to interpret and apply it. That's key for balance.
Right, checks and balances.
Exactly. Second, the sheer complexity of drafting. Legislators try really hard to be clear, use unambiguous language, but laws get debated, amended. Things can get added or changed during enactment that introduce uncertainty.
So the process itself can muddy the waters.
It can. And maybe most importantly, there are unforeseen situations. Laws are written at a specific time, right? But they have to be applied in a world that changes, often in ways the original drafters just couldn't have imagined. This can lead to ambiguity, or even totally absurd results if you just stick rigidly to the text in a new context.
So it's almost like language itself is the built-in challenge here.
Precisely. There's a great quote from legal scholars James Holland and Julian Webb. They said, "Words are an imperfect means of communication."
That sums it up.
Yeah. They point out omissions can happen during drafting, words can be ambiguous, meanings can change over time, drafters might overlook specific points, or just fail to adapt the law to new developments. It really captures why interpretation is so unavoidable, so vital.
Okay, so given that language is imperfect and interpretation is absolutely crucial, let's get into the tools. We often hear about the rules of statutory interpretation, but I gather that term rules might be a bit misleading.
It definitely is. That's a really important point. It's much better to think of these as approaches rather than strict binding rules, like, say, the rules of a game.
Okay, approaches, not rules.
Yeah, think of them more like different lenses a judge can look through. There isn't a strict order, no hierarchy saying you must use this one first, then that one.
Right.
Often, judges actually use what they call an amalgam, a mixture of these approaches, to get to what seems like the most sensible and just interpretation in that specific case.
Okay, that clears things up. So with that framework approaches, not rules, let's talk about the traditional ones. First up, the literal rule.
Right, the literal rule or the literalism approach. This one's probably the most straightforward on the surface. It basically says you have to interpret words in an act according to their ordinary literal dictionary meaning.
Just read what it says.
Pretty much. The thinking behind it is that this is the best way to figure out what Parliament, the draftsman, originally intended. We've seen it used here in Uganda, like in a case called Sarogandesha v. Transroad Ltd., where the court explicitly gave words their ordinary natural meaning.
It sounds simple enough, but what happens if taking the words literally leads to something completely crazy or unfair, something Parliament clearly couldn't have wanted?
And that's exactly why we have the next approach.
Yeah.
The Golden Rule.
Ah, the backup plan.
Sort of.
Yeah.
The Golden Rule allows a judge to modify that literal meaning, but only when necessary. It says you should interpret words or sections in the context of the entire statute.
Okay.
Specifically to avoid an absurdity, an inconsistency, or some major inconvenience that a purely literal reading would cause.
So it's like a common sense check on the literal rule.
Exactly. It's like saying, okay, this word usually means X, but applying X here leads to a ridiculous result that Parliament surely didn't intend. So we can tweak the meaning slightly to make it sensible within the context of the whole act.
Can you give an example?
Sure. There is a case, Stephen Sarawaji Kavuma v. Barclays Bank, where the court used the Golden Rule. They looked at the statutes as a whole to avoid an outcome that just wouldn't have worked logically or practically if they'd stuck to a purely literal reading of one part.
Got it. So the Golden Rule is the literal rule's sensible friend. And then there's the third traditional one, the Mischief Rule, or Hayden's Rule. This one feels like it digs into the why behind the law.
It absolutely does. The Mischief Rule tells judges to interpret an act based on its general policy, and specifically the mischief, the problem or the evil, that the act was originally designed to fix or remedy.
So you have to look back in time.
Essentially, yes. To apply it, you kind of become a legal historian for a moment. You need to figure out, what was the law before this act? What was the specific problem or mischief that the old law didn't cover? And what remedy did Parliament decide on to fix that problem? What was their true reason for the reform?
And when would a judge typically use this one?
Usually when the words themselves are ambiguous or the literal approach doesn't quite work, and you need to find a slightly broader meaning to actually achieve what the law was trying to do, its underlying social purpose.
Okay, so those are the sort of foundational approaches, but it's clear, law isn't static, language evolves, so it's not surprising that judges' thinking has moved on too, right? Leading to more modern ways of looking at legislation.
Indeed. These modern approaches tend to offer an even broader perspective, often looking beyond just the text itself. And the most significant one really is the purposive approach.
The purposive approach, okay.
This is where judges focus on the fundamental reasons why an act was passed in the first place. They then try to give the words a meaning that's consistent with that overall general purpose or objective of the legislation.
Now, that sounds a bit like the Mischief Rule, trying to find the intention. How is the purposive approach different? You said it's broader.
That's a great question, and it's a key distinction. The Mischief Rule looks back, focusing on fixing a specific defect in the old law. The purposive approach is, well, wider.
Wider how?
As the scholar Glanville Williams put it, it's more about promoting the overall social purpose of the current act itself, not just remedying a past mischief. It's seen as a more modern, perhaps more liberal style of interpretation.
Ah, okay.
And honestly, it has largely overtaken both the literal and the mischief rules. Many see it now as the proper approach for figuring out Parliament's will.
So if I'm getting this right, it's not just about what the words literally say or even what specific problem they fixed back then. It's more about the bigger picture. What goal is this law trying to achieve in society today?
Exactly. It's like focusing on the destination the law is trying to reach,
Right.
rather than just rigidly following the original map directions, especially if the landscape has changed.
That gives courts quite a bit of flexibility, doesn't it, to keep laws relevant?
It does, and we've seen it used effectively in Ugandan courts. There's a case, Uganda Revenue Authority v. Speak Hotel, where the purposive approach was explicitly called the correct one, especially where the language was a bit ambiguous. It led to an interpretation favoring the taxpayer based on what the court saw as the law's overall purpose.
Interesting.
And another one, Uganda Revenue Authority v. China Jifang, used the purposive approach to resolve ambiguity by really zeroing in on the main goal of that specific piece of legislation.
Fascinating how shifting the approach can really change the outcome. Are there other modern approaches worth mentioning?
Yeah, a few others pop up. There's the teleological approach, which is even broader than purposive. It considers the overall spirit or general scheme of the legislation, often used in, say, European Union law.
Spirit of the law. Okay.
Then Sir Rupert Cross suggested a contextual approach, looking progressively at the ordinary meaning. Then the wider context within the act, then the historical context that led to its creation.
Layers of context.
Exactly. And there's also talk of an integrated approach, which basically means using a careful mix of the language, the statutory context, and any other aids available. It just shows there isn't one single modern method, but rather a move towards more purpose-driven, context-aware interpretation.
So many layers. Now, beyond these broad approaches, you mentioned earlier there are also specific rules of language, like micro tools to use on the text itself.
That's right. These help judges drill down into the specific wording. The whole act rule, for instance, is pretty fundamental. It just means you have to read the entire act together, assuming Parliament meant it to be consistent and coherent.
Makes sense. Don't read sections in isolation.
Precisely. Then you have things like the justum generis rule. Bit of Latin there.
Okay, what does that one mean?
It means of the same kind. If a law lists specific things, say dogs, cats, rabbits, and then follows it with a general term like and other animals, that general term, other animals, is restricted to things of the same kind as the specific ones listed.
Ah, so in that example, it would mean other domestic pets. Probably not, like lions or whales.
Exactly. It limits the general words to the genus or class set up by the specific words.
Got it. What else?
Another Latin one. Nociter associus. It is known by its associates.
Known by the company it keeps.
You got it. A word's meaning can be clarified by the other words around it in the sentence or section.
Can you give an example?
Sure. Think of the word interest. If a law talks about interest, dividends, and capital gains, interest clearly means financial return. But if it talks about right, title, and interest in land, interest means a legal stake or share in the property. The surrounding words tell you which meaning applies.
Okay, context is key again.
Absolutely. Then there's expressio unius est exclusio alterius.
Wow, more Latin.
Yes. This one means the express mention of one thing excludes others. So if a law says permits are required for lorries and buses, it implies that cars or motorcycles don't need that specific permit because they weren't mentioned.
If it's not on the list, it's not included.
Generally, yes, that's the presumption. And one more, generalia specialis non derogant. This means general things do not override specific things. If you have a general rule in a statute, but also a specific rule dealing with a particular situation, the specific rule usually takes precedence over the general one for that situation.
That seems really important for avoiding contradictions.
It is. It helps make sense when laws have both broad statements and specific exceptions or provisions. The specific usually wins in its narrow area.
Okay, that's a really useful set of language tools. Now, beyond these internal rules, what about aids to interpretation? Things from outside the main text or maybe parts of the act itself that aren't the core rules?
Yes, these aids are crucial. They fall into two main camps. First, you have internal aids or intrinsic aids.
Inside the act itself.
Right. These are parts of the act document that aren't the main operational sections but can still shed light on meaning. Think of the short title, the common name of the act. The long title, which usually gives a fuller description of its purpose. The preamble, if there is one, often sets out the background and reasons for the law. Headings of different parts or sections. Marginal notes or side notes in the margins, though their status can sometimes be debated. Provisos clauses, starting with provided that, which introduce exceptions or qualifications. Interpretation sections, which define key terms used throughout the act. And schedules at the end, which often contain lists, forms, or detailed provisions. All these internal elements can give clues to the intended meaning.
And the second camp, external aids.
Exactly. External or extrinsic aids. These are things found completely outside the act itself.
Like what?
Well, a big one in Uganda is the Interpretation Act, Cap 2. It sets down general rules for how all statutes should be interpreted. Then you might look at statutes in peri materia, other acts dealing with the same subject matter. They can provide context.
Okay.
The historical setting, what was going on in society when the law was passed. Reputable dictionaries, obviously, for word meanings. Legal textbooks and scholarly articles. Reports from law commissions or inquiries that led to the legislation being drafted.
What about parliamentary debates? Can judges look at what was said when the law was being made?
That's a really interesting one. Traditionally, courts were reluctant, but the famous UK case, Pepper v. Hart, opened the door, allowing courts to consult Hansard, the official record of parliamentary debates in certain, quite specific circumstances, usually to clarify ambiguity if a minister made a clear statement about the intended meaning.
So sometimes yes.
Sometimes cautiously. And of course, previous judicial decisions, case law, where courts have already interpreted the act or similar provisions, are a major external aid.
That is a seriously extensive toolkit judges have.
Speaking of the acts themselves, you mentioned different types earlier. Could you quickly recap the main kinds of acts Parliament might enact based on what they do?
Sure. You have amending acts, which simply change parts of existing acts.
Right.
Repealing acts, which get rid of an old law entirely. Consolidating acts are useful. They bring together an original act and all its later amendments into one single clean act. Makes the law much easier to find and read.
Definitely helpful. Enabling acts grant powers, often setting up government bodies or agencies, like the act that established the National Identification and Registration Authority, NIRA.
Okay.
And codifying acts aim to bring together all the law on a particular subject, both previous statutes and relevant case law, into one comprehensive statute. Uganda's Contracts Act 2010 is a good example of trying to codify contract law.
That clarifies the different functions well. Now, another key distinction seems to be between primary and subsidiary legislation. What's the difference there?
Yes, absolutely crucial distinction. Primary legislation is the acts of Parliament themselves. These are the main broad laws passed directly by the legislature. They usually deal with substantive matters, setting out rights, duties, powers, and they generally take quite a while to get through the whole parliamentary process.
The big laws.
The big laws, exactly. Secondary legislation, on the other hand, is also known as subsidiary or subordinate or delegated legislation.
Now that's a name.
Yes. But they all mean the same thing. Rules, regulations, orders, bylaws, statutory instruments, etc. These contain the detailed, often procedural rules needed to make the primary act actually work in practice.
And they're made differently.
Yes. Crucially, they are made under the authority granted by a specific primary act. So an act might say the minister may make regulations for whatever. Those regulations are secondary legislation. They can usually be made much more quickly than primary legislation.
So the act sets the framework, the regulations fill in the details.
Precisely. In Uganda, the Interpretation Act simplifies things a bit by generally referring to all forms of secondary legislation as statutory instruments.
Got it. And finally, just briefly, the anatomy. How is a typical act actually structured on the page?
It follows a fairly standard structure. You'll have the short title, the common name, the long title, the fuller description, often the date of assent, when it became law, the words of enactment, the formal phrase, making it law. Then the main body is divided into sections, usually numbered sequentially. Sections can be broken down into subsections, typically using numbers in parentheses like 1, 2.
Right.
Subsections might be further divided into paragraphs, often using lowercase letters like A, B, and paragraphs can sometimes even be broken down into subparagraphs, often using Roman numerals like I, too. It's a very hierarchical structure designed for precision and easy referencing. And sometimes you have schedules at the very end for lists or forms.
Incredibly organized. So when judges are doing all this interpreting, applying the approaches, and using the aids, are there certain background assumptions or presumptions they bring to the table, like default settings for reading laws?
It's a great way to think about it, yes. Judges do apply certain policy-based presumptions,
Yeah.
unless the act clearly says otherwise. For instance, there's a presumption that words referring to the masculine gender also include the feminine.
Okay, practical.
A very important one is a presumption against laws having retrospective effect, meaning a law generally only applies from the date it comes into force onwards, not to events that happened before, unless Parliament explicitly stated it should be retrospective.
That seems fair.
Yes. Judges also presume that Parliament doesn't intend to produce results that are highly inconvenient or unreasonable, and there's a principle often called the always speaking principle.
The always speaking principle, what's that about?
It means that an act is generally interpreted as if it were, well, always speaking. It should be applied to the circumstances as they exist now, even if those circumstances didn't exist when the law was written.
So it helps keep old laws relevant to new technology or situations.
Exactly. If a 100-year-old law refers to documents, the always speaking principle might allow a court to interpret that today to include electronic documents or emails, even though the original MPs only knew paper. It gives laws a kind of dynamic quality.
Very clever. And what if two acts seem to conflict? Maybe an older one says one thing and a newer one says something different about the same issue.
Good question. A fundamental principle here is the supremacy of later statutes. Generally, if an earlier act conflicts with a later one, the later act prevails.
The newer law wins.
Usually, yes.
Yes.
The assumption is that Parliament knew about the earlier law and intended to change it with the later one, reflecting perhaps updated societal needs or thinking. It assumes the legislature keeps up to date. This was highlighted in a Ugandan case, OCDB Womono v. Okelo Osun, which itself relied on an earlier ruling in URA versus Uganda Electricity Board.
Makes sense the most recent statement of Parliament's will should take precedence. Now, we focused heavily on acts of Parliament. Do similar ideas apply when interpreting other kinds of legal documents like, say, deeds for property?
Very much so, yes. A deed, remember, is a formal legal document. And courts use similar principles to interpret them. For instance, there's a principle often stated in Latin, ut res magis valet quam periat.
Which means?
It means the interpretation should support the validity of the thing rather than destroy it. Basically, try to interpret the deed in a way that makes it legally effective, not void, if possible.
Makes sense.
You also read the deed as a whole, looking for consistency. The primary goal is always to give effect to the intentions of the person who made the deed. If the meaning is genuinely uncertain after looking at the words, the court will usually lean towards an interpretation that makes the deed valid.
And what if it's really ambiguous?
Interestingly, with deeds, if there's deep ambiguity in the wording, courts might be willing to accept parole evidence.
Parole evidence?
Yeah, that's external evidence, things outside the four corners of the document itself, like testimony about what was intended or related documents to try and figure out the true meaning. That's often harder to do with statutes.
Wow. Okay, we have covered a huge amount of ground today. From why we even need interpretation, through all those traditional rules, modern approaches, language tools, aids, right up to deeds.
It's definitely a complex landscape. What I hope comes across is that interpreting laws, especially acts of Parliament, isn't just a simple mechanical process. It's multifaceted.
Right.
It involves combining these traditional rules, these newer approaches, specific language rules, using various internal and external aids, and keeping those background presumptions in mind.
And crucially, as you said, there's no single strict hierarchy or order. Judges have to choose the right tools for the job.
Exactly. And that choice, which approach or aid they emphasize, can genuinely influence the outcome of a case. It really highlights the skill and, frankly, the power involved in judicial interpretation. It's as much an art as it is a science sometimes.
A complex, dynamic dance indeed. So for everyone listening, trying to digest all this, what are the absolute core takeaways? If we think about that framework from Amanda Powell and Natasha Coolhan you mentioned.
Yeah, they provide a really helpful, concise way to think about applying these principles. First, you probably start by considering a rule of interpretation. Often the literal rule is the initial go-to.
Okay, start literal.
But then second, and this is crucial, always consider the purposive approach. What was this law trying to achieve? Let that guide you.
Purpose is key.
Third, support your interpretation. Use the rules of language, especially if you're dealing with lists or tricky wording, and bring in relevant aids, whether they're internal to the act or external.
Back it up with evidence.
Exactly. And fourth, always keep those general legal presumptions ticking away in the back of your mind. They're like the default settings for understanding the law.
Start literal, think purposive, use aids and language rules, remember presumptions.
Got it. That's a great summary.
Hopefully helpful. Definitely. So here's a final thought to leave everyone with. Considering everything we've discussed, that words are imperfect, that legal interpretation uses all these different rules, approaches, aids, and presumptions with no strict pecking order, what does this actually tell us about the nature of law itself? And maybe about the huge responsibility that rests on the shoulders of those who interpret it. Something to mull over until our next deep dive.